This bill should be very familiar to the committee. It is the exact same bill as last year, which passed the House, made it to the Senate. Unfortunately, did not make it all the way through the process. But this is dealing with an issue related to the elimination of caps for non-economic damages that occurred recently. You know, Missouri has had a long history which was establishing caps for non-economic damages, and it has established constitutionality of those caps. And in 1992, the court upheld those caps in a 6-1 vote in the case Adams versus Children's Mercy Hospital. But in the recent ruling, Watts v. Lester E. Cox Medical Centers, not only did they overturn the Adams decision and previous decades of court rulings, but they, in essence, did it in a unique way where they challenged the authority and the power of the General Assembly to define law and establish or attempt to enshrine English common law into today. Now, the majority opinion was using the word heretofore enjoyed, and so this is kind of a recap of last year. Maybe you still remember how this happened, but they used the phrase that's in the Constitution as heretofore enjoyed, and by making reference that because it had been enjoyed up until that time, they're referencing that it must have been enjoyed through common law, which was established in Missouri statutes. And so the intention of this bill is to reestablish the first section of Missouri statutes where we establish common law, and because in essence what we're doing in the statutes, the very first section of statutes is common law, but the rest of our statutes are a but-for. In essence, we are saying we recognize common law but for all of the things that we proceed to define in the rest of our statutes. And so, in essence, we're underlying the but-for, and that's what this bill is doing, is strongly underlining that we have the authority in the legislature to establish, we have the authority in the legislature to create a cause of action for medical malpractice, to establish this, and we certainly have the authority to place caps on it if we're going to establish it. It is extremely important that we place caps. Consumers know how expensive maintaining personal health insurance is, and they are aware of the soaring premiums that we're experiencing not only in Missouri but all across the United States. The Missouri Department of Insurance in 2011, in their report, they noted that the number of individuals with pending claims, or the claims at year-end, had reached an all-time low in 2011. That 2011 low was after reaching a peak in 2005, before our caps had been put in place at 350,000. So after the caps had been put in place, we did receive a low, or we saw a decline in the number of suits that were filed in the state of Missouri. One of the things that you'll hear is that the placing caps does not affect the amount of the premiums or the costs, but that is clearly not the case. When the volume of claims are declining because of by us putting caps in place, we know that reducing that volume has reduced the cost for medicine and reduced the insurance premiums in the medical community. The goal is also to encourage job creation and relieve those who are working in Missouri's medical field. We know that in states such as Texas, where they have dramatically changed the tort system in Texas, they're receiving a flood of license applications for physicians in those states. And so when you talk to students that are graduating from medical school, where they're looking to go, Missouri right now is not a hospitable environment for providers in the medical community.
And we're encountering ourselves problems in just recruiting physicians to Missouri already, having looked over the last year, really not getting a lot of response from physicians when we try to recruit them. issues with tort and malpractice being only one of those issues, obviously. I personally, fortunately, knock on wood, if you will, have had no direct experience with malpractice claims or cases. That's fortunate. I think that has to do with the way we try to practice medicine, know our patients, to build those relationships. But even without any prior claims or experience, unfortunately, insurance companies do look at their actuaries calculate the future and just try to estimate their costs. So even before we may see cases, begin to build and the claims rise, the malpractice premiums will certainly rise in advance of that.
A lot of the testimony that would be, I think, on my bill is identical in subject matter regarding medical malpractice to what you're hearing in the non-constitutional amendment approach to dealing with tort reform. My bill differs in the vehicle that we're going to do it. We've had a little discussion on the constitutionality of the preceding bill. I do want to mention I do support the bill that was in front of me. I support tort reform. This is, I think, another option that we can look at. I would like to comment, my bill is a little different, my resolution. It deals with medical malpractice. It's modeled after the Texas statutes, which have upheld a constitutional challenge in the federal courts. I have a second part to my malpractice bill, however, which addresses some of what I think I heard some questions on here about the topic of non-economic damages on things other than medical malpractice. My paragraph, the second part of it, deals with all non-economic damages. It does not set a cap. It allows the legislature in both medical mal in the first section and in all other scenarios, contract, tort, to authorize the legislature, if it's in their decision, to set caps for non-economic damages. So it is medical malpractice, but it also has a second component. I do not have suggested valid language at this time because of the components of the bill. I indicated last year with this very similar bill, we're very willing to work with the committee and other interested parties to, if I would think some crafting would happen to before this would ever proceed to a floor, and at that time after the crafting I would request an amendment or a substitute bill that would then have actual ballot language on it.